And good afternoon, everybody. This is Vinny Maletti with Maletti Law, the strongest name in law. The date now is November 2nd, 2021. It is Tuesday. The time now is 3:09 p.m. And the title of this video is Derivative Claims Made Easy. Derivative Claims Made Easy. First and foremost, make sure you click the subscribe button so you can go ahead and subscribe to the channel. More subscribers, the better. We're going to be able to start branding, having cooler content. YouTube does all kinds of cool things when we get to a certain number. So make sure you subscribe. Let your friends know. Also, make sure you go to the website, www.malettilaw.com, www.malettilaw.com, and just make sure that you sign up to the newsletter. Obviously, you want to always be in the know. You always want to have all the fresh new content as it comes out. Obviously, you're all aware we have a new we have a new member of the firm today. His name is Flex. He's sleeping because he's permanently attached to me. So at any point in time, you see a Jack. What he's called, like a Jack Russell, just randomly jumping up and down, maniacally in my office. Just know that's the newest member of the firm. All right, so let's get down to it. So, all right, so it sounds complicated. Derivative claims, right? Derivative claims. This is a creationist statute. Basically, the term derivative refers to the action derives from something else. The harm, something derives from something else. So the action, the claim derives from something else. So keep that in mind when it's a derivative interest, a derivative claim. So here's a typical scenario. You are a shareholder. Well, first of all, what's a derivative action, right? So we started by saying, and I took notes, very excited to myself. So basically, this is this lawsuit, a specific type of lawsuit that's brought by a shareholder or some kind of managing member in some kind of LLC or corporation or something. So it's somebody that typically has some kind of equity rights, some kind of shareholder rights into some sort of entity or some sort of financial vehicle or structure. So basically, it's a lawsuit brought by a shareholder. It's brought on behalf of that corporation, hence derivative. So it's Vinny Maletti. Vinny Maletti brings this derivative action on behalf of Maletti Corp. So the shareholders bring the action on behalf of the corporation. And so that's essentially what a derivative action is. It's a particular shareholder is bringing an action on behalf of the corporation that they are a shareholder of, that they are a member of, and they're bringing it derivatively because their action derives from the harm suffered by the corporation. Where do you see this? So you'll see this a lot in situations where you have shareholders, members, and other people, parties that have equitable interest in companies and properties. So keep that in mind. You see this a lot when you see the term shareholder, when you see the term member, when you see the term partner, membership units, shareholder units, specific shares, Class A, Class B, whatever the case is. But you see these actions having to do with shareholders. These are people or other entities that have, these are people that have equitable interest in companies. Equity meaning some kind of financial interest, some kind of ownership interest in the company. Sorry, there's a lot of terms. I'm trying to break this down. So to what benefit do you bring these derivative actions? So a lot of these derivative actions, they have a lot of benefits to them, right? So let's give you a scenario. So I'm the shareholder and I want to, I'm looking at these board of directors for this company that are just like taking all kinds of terrible actions and engaging in corporate waste, engaging in all kinds of garbage, right? So, but let's say I'm a shareholder and I'm a minority shareholder and I don't have the ability to sue because nothing in my paperwork says I'm allowed to sue. None of my paperwork says I could sue the board of directors or I even have any equitable interest, right? Well, there's a creationist statute that allows you to bring derivative actions. So essentially, this creates a cause of action where you may not have a cause of action otherwise. It might give you another bite of the apple. In some instances, a shareholder is able to sue the board for something, but this also permits them to sue kind of like at a different angle, right? To sue not only in terms of the individual, but in terms from a derivative claim. So it kind of gives you the ability to sue a second time. It's also another way to get damages if you want to really sue a company, let's say, and get as much as you can get back. Not only do you want to get back your individual damages, but you want to get the damages that the company suffered as a result of the mismanagement. So they can get some damages like that. It's another way to get damages. It's another way also to get attorney's fees. Statutes permit attorney's fees to be recoverable in derivative lawsuits. I mean, I could tell, ironically, I know Delaware's code better than I know New York's code. Delaware by statute permits derivative actions. So and the reason why I say Delaware is most companies will incorporate Delaware because Delaware has the most consistent business code. So most companies will incorporate in Delaware. That's why they incorporate in Delaware, by the way. It's the most consistent like business forum. And I mean, they have a long line of like judges that are really committed to like business developments, like judges like Easterbrook. I mean, well, he's not there anymore, but but like a long history of that, like prominent judges. Um, so your Delaware code permits attorney's fees to be recoverable for derivative claims. So let's say you have an individual claim, you want to get attorney's fees back, you can get them as a derivative claim under the Delaware code, assuming Delaware is the proper law and jurisdiction. When does another question I usually ask is, who may bring it, right? So who brings a derivative action? A derivative action is generally brought by the shareholders of a company. It could be one shareholder, a minority shareholder, it could be a majority shareholder, but the shareholders of any company, the members of any LLC, the partners within any partnership, those are the shareholders that will be able to bring a derivative action. Again, you see most with LLCs because LLCs really create like a lot of LLCs. You could really create whatever you want in terms of a corporate structure. So having this kind of stuff in the statute provides that balance for you. So when does it make the most sense? It really makes sense in two instances. One, when you assume there's a lot of corporate fraud going on or a lot of corporate mismanagement. So let's say the board of directors is like really silly. The board of directors is like really stupid, let's say. It's just they're like just egregiously just diluting the company's interest left and right, company's money left and right. So this makes a lot of sense to bring a derivative action because it gets you in the door. You might not be able to sue them otherwise. This gets you in the door. The second situation is when it's a non-publicly traded company. So when a company is a publicly traded company, all their paperwork is basically just left out, right? So all their stuff is publicly filed, all their information is publicly filed. So if it's a non-public company, you don't have that ability. So this is very helpful for the non-publicly traded company when you want to sue them because it gives you an ability to jump in. And it gives you an ability to subpoena documents and to, interrogate people and subpoena people for a conversation, which you might not get otherwise. So so it really makes the most sense in two situations. It makes the most sense where the corporate fraud is like really like ravenous, like a lot, like abundant. And it also makes sense when we deal with a non-publicly traded, like closely held private company. Generally, how does it work? Essentially, the shareholder, the particular shareholder who wants to file a derivative action will file their derivative action. They likely will be asked for a bond. I'm not really sure in what situations you wouldn't. In like the 3 or 4 cases they've had like bonds for the actual amount you're seeking in terms of damages. So which was high. So keep that in mind. If you're going to bring a claim like this, there's a possibility. The strong possibility you might have to post a bond for this. There are bond companies that you could pay for to jump into the litigation to post a bond for you. I mean, I can't remember off the top of my head, but I do remember in one instance we had the bond company that posted a bond for us. So and it wasn't even that bad. It was a couple thousand for like hundreds of thousands. So it wasn't even that bad. And plus you got it back during the litigation, right? That was like a talking point. And also, you have to submit a demand. You can make the case that the demand is futile, meaning so you have to submit kind of demand of what you want to cure your damages. So in order to open up the shareholder derivative claim, you have to submit a demand where you are seeking what you want. You send a letter seeking X amount of damages in order to resolve the case. So that's one thing. So that's another thing. So how does it work? You most likely will have to submit a demand. Unless you want to assert that the demand is futile, which then that becomes like a whole song and dance, which you have to do, which you should discuss with your attorney with. That's more than the scope of this video. And the second thing is you'll likely have to post a bond, probably called an undertaking. I've only seen bonds. I've never seen one where a bond hasn't been filed. I've only seen bonds. So I'm not sure if that's required or not. But in every case I've been in, it's been required. And it's always been some amount of like what you're claiming. I think almost in every instance we've retained like a bond company to pick it up and get involved. So that's that. So there you have it. So derivative claims made easy. It's a very a complicated word. It sounds more complicated than it really is. It's actually quite complicated, and drafting complaints for it sucks. But it's helpful because it opens up avenues you may not have had otherwise. And the reality is, you could really use that, especially like in this day and age where everything is kind of like I just feel like it's just so much. There's so many barriers to just everything, and the law is so complicated at this point that like everything's like precluded. There's a carve out for everything, right? So it's very helpful. So that's my only thought. If you have any questions, obviously, please leave them in the comments below. You certainly can email us. You certainly can send me an email at vmaletti, VMILETTI at malettilaw.com, MILETTILEW.com. Again, subscribe to the YouTube channel. Send a letter for sign up for our newsletter at the website. I'm sorry, I keep checking on the dog. The dog's unusually quiet and not whimpering, and usually he's attached to my lap, which I've had an endless amount of fur on me for the past couple of days. So as always, yours and Law's love and lifts, and I hope these videos are helpful. And have a great day.